the cases themselves were very, very small, not important, not big amounts of money, not human destinies. No, there were. That's why the court was more creative, perhaps. The problems the court faces when it has to interpret the Brussels Convention or other regulations concerning civil law cooperation is how to qualify some terms in these regulations. We speak about civil law. The regulation, I repeat, I talk about Brussels 1A regulation, but it's the same for the other regulations, deal with a lot of, let's say, classical civil law terms. For example, Article 1 of the Brussels regulation speaks about civil and commercial matters. What is, but without defining it, what is civil and commercial matter? How to interpret this notion? We all know that in different legal systems of the member states, and others, but let's stay at the member states, the notion of civil law has different meanings. Or commercial law, does it exist? There are immense doctrinal discussions about the existence of commercial law, about its extent and so on. And now the Court of Justice in Luxembourg must decide whether a special litigation enters into this term. It's very simple to say this is an autonomous term of the EU law, but this is the first step in reasoning of the court. Now you must say, what is it? Civil in the sense of European law. And of course, as you know, the civil law is not codified in the European Union. There are some parts of it, consumer protection and similar, of course, some little pieces of family and succession law, but not really, or bankruptcy law. They're not really regulated in the details. So this is a big problem for the court, which we find nearly in every case concerning interpretation of this convention. Or let's say the term of court, which exists also in the Article 1 of the regulation, court judgment. What is a court? Here we have the legislator tried to help the interpretation of this term, inserting in Article 3 the exceptions valid for Hungary and Sweden, where it is written that the Hungarian notaries and the Swedish enforcement institution are courts in the sense of these regulations. But this is very limited, and Vesna already mentioned the cases of Pula Parking and Zulfikar Kasic, and there is one recent one also Croatian, Obala Ilešić, where the problem of notaries to which the Croatian legislator transferred the former competencies of courts are not, after European law, courts in the sense of the Brussels Convention. So the qualification is here rather formal. But let's, and I'm sorry, let's nevertheless finish with a case, very simple one, which shows the way of reasoning of the court. It is a small case, Granarolo versus Ambrosi concerning the well-known question which occurs every day. The distinction between contractual matters and tort or delictual matters in the sense of Article 7 of the Brussels I regulation. The story is a short one. Granarolo is a producer of milk products, especially cheese in Italy, and it has exported cheese to the French company Ambrosi for 25 years. There were regular deliveries and regular payments. By the way, why the French import Italian cheese, I can't really understand, but tastes are different. And with France, we see there 1,000 or 2,000 kinds of cheeses. Who buys Italian ones? But it's not a legal issue. After 25 years of this cooperation, without any problems, Granarolo, the Italian company, wrote a letter to Ambrosi that it was a letter from, I think, December 12th of one year, that from the 1st of January of the next year, they will stop their deliveries. And the French company, the Ambrosi, sued them, Granarolo, before the Tribunal de Commerce de Marseille, the commercial court of Marseille in France, on the basis of, these are the terms of the action, abrupt termination of a business, of a long-term business relationship. The problem occurred before the Tribunal de Commerce de Marseille and later before the Cour d'appel de Paris was the following: whether this action is a contractual one or a delictual one. And of course, the competence of the court, the territorial competence, depends on this issue, because if it's a tort, delictuous liability, the French court is competent. If it is contractual, Article 7.1 would be applicable. The place of the performance of the contract, as the contract was a contract of sales, the place of the delivery, the place of performance is the place of delivery, and as in their relationships it was agreed, the clause ex works of Incoterms was applicable, so the place of delivery was Italy, Bologna, and the Italian court would be competent. So the question, contractual or delictual matter. The French Code de Commerce, commercial code, contains a provision saying that abrupt termination of such a contract is a delictual matter. And the court in Marseille, of course, accepted this qualification under French law. The Cour d'appel de Paris, however, was not sure and sent the preliminary reference to our court. And now the story begins. We, of course, we first very firmly repeated the rule which has been well known. The term delictual or contractual must be interpreted after EU law. National law does not matter. So the first reply is the provision of the French commercial code is not relevant. It doesn't exist for the Court of Justice. So, and this is the important message from this judgment. Afterwards, the difficulties restart. All right, it's an autonomous notion of the European law, so let's define it. And of course, there is no definition in the EU law. So, firstly, the court must deny the application of national law, which is the general rule. The Court of Justice never interprets national law, at least in theory. And afterwards, you must define the notion. So you come back to the national law, not the French or Italian one in our case, but the rules common to member states. And we are often placed before this question. What are now, let's say, just civil laws, civil regulations common to the member states? We are not going to count them. There's no member states which is more important than the others. We have different linguistic versions which differ. So now the court should enter into creation of a rule, sometimes said that it's drawn from the hair, or from the clouds. It can be more or less right, this our approach, but there's no other. You must decide. So the very problem concerning the civil law regulations is how to define civil law, classical civil law notions, which are not found in the European law. You can, without any problem, say, okay, national law is not to be applied, but afterwards you must try something new, something common. And this is the eternal problem of our court. I could continue with cases, with examples of this kind, but I hope that I just a little bit explained what kind of reasoning stays behind our judgments, which are finally published and known and commented all over the Europe or all over the world. And I hope that I provoked some thoughts in your heads. And of course, I hope that I convinced you that judges of the court in Luxembourg, who are not always right, our work is not always easy. Sometimes it's fine to be a judge, sometimes not. But what is clear, I hope, we are never boring. Thank you.